Okay, hello everyone. Thank you for attending this ISILL Talk series. My name is Zaki. I'm a lecturer at Venus University. I'm also one of the board in ISILL. And this morning, we're going to discuss about enforcing international law, legal, political, and economic perspective. And of course, we have a prominent speakers for this opportunity. They are Professor Shafi Naldi SH-MCL from Universitas Islam Riau, Febrian Rudiat, Bapak, Director General of Multilateral Cooperation Indonesia MOFA, Scott Thomas Bruce, Office of Counter-Proliferation, Department of State, USA, and Peter Zhang, Associate Foleyhoek, LLP. But before we start this event, let's listen the opening remarks from Dr. Ari Afriansyah as Chairman of ISILL. Dr. Ari, please, time is yours.
Thank you, Pak Zaki. Assalamualaikum warahmatullahi wabarakatuh. A very good morning to everyone. Thank you very much for the speakers. Let me say hello to Pak Dirjen, Pak Febrian Rudiat, our Director General of Multilateral Indonesian MOFA, Professor Safri Naldi, our member of experts at the association, Mr. Scott from the Department of State, the United States, and also Peter, my dear colleague from the Foley and Pike. We are so privileged to have this session this morning because this is really, really important and really relevant for our current situation because, again, the very cornerstone of international law has been challenged by the fact of international relations nowadays. Every time that I have to teach international law, one of the questions has been posed is that is international law is a law if we talk about the enforcing of international law. Again, this is something that we need to discuss based on our current situation. We know that here we have so perfectly have a resource persons. We have a professor of international law. We have the government of Indonesian side. We have also the government of the United States, who we do believe as the prominent states, and also Peter as the legal practitioner who the law firm have been represented the states in terms of the litigation before the international court. I guess our association is thankful and really privileged to have this discussion, and I'm pretty sure that our members will have also the same privilege. Again, I don't want to take very much longer time because we have a challenge of time. We are in Jakarta and also in Washington. We have 11 hours time difference. So I guess we will have to make the most of the time. Thank you very much again for the speakers and for the participants. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi. Thank you very much, Pak Dr. Ari, for your opening remarks. So don't forget to join this association for all international law lecturers, because we have a lot of prominent international law professors and also great events every year. Now, let me introduce the moderator this morning. She is Fatma Mutia. She is a lecturer at Universitas Tanjung Pura. So please welcome Fatma to lead this ISIL talk.
Apologize. Yeah, I thought I already unmute my microphone. Thank you, Mr. Zaki, for the introduction. Assalamualaikum warahmatullahi wabarakatuh. Good morning to all the speakers and participants of this seminar, and good evening to some of the speakers based in the Washington, D.C. It is an honor to be the moderator today. Firstly, I apologize for the inconvenience if you may hear some sounds in the background because there is a renovation going on my office, so I'm sorry. So the theme of today's seminar is a very interesting one, sparked by one question of how international law be enforced, if at all. A question that is often raised every time I teach international law class, as Mr. Ari said in my university. And indeed, the discussion about the enforcement of international law is an interesting topic. So with that note, today we have several distinguished guests who are expert in their respective fields. So I'm sure we are going to have an insightful and informative discussion today. I'm sorry if it is quite loud in the background, I'm sorry. Before we go on to the main event, let me inform you about the rule of today's seminar. The seminar will be divided into two sessions. The first session will be the presentation of the speaker, and each speaker will be given 15 to 20 minutes to speak. And then we are continuing to the second session of question and answer, where the participants are invited to ask a question to the speaker. So to make the time short, ladies and gentlemen, I am honored to introduce you to our first speaker, Professor Dr. Haji Syafrinaldi SHMCL. He attained his bachelor degree at Faculty of Law Universitas Andalas in 1988. He attained master's degree at the Faculty of Law at the Delhi University in the field of comparative law. He attained his philosophy of doctor degree at I'm sure I will misspell this, Faculty für Sozialwissenschaft, University der Bundeswehr München. I'm sorry for the bad pronounce, in Germany in 2000. And he is currently served as director of Universitas Islam Riau, and he has published several publications at national as well as international level, focusing among others law of sea and intellectual property law. So with that, I would like to welcome our first presenter, who will deliver a presentation entitled The Concept of International Law Enforcement. So Prof. Syafrinaldi, the time is yours.
Assalamualaikum warahmatullahi wabarakatuh. Very good morning, everybody. Thank you very much, Mbak Fatma, as the moderator of today's international webinar, Dr. Ari, and Pak Zaki, everybody participants of this webinar. I'm honored to be one of the speakers this morning. And please can you show my slide, please? Mbak Fatma?
It's coming, Pak. It's coming.
It's coming. Please show my slide, please. Okay. Well, actually, what I want to talk this morning, just in view of my opinion as academicians of international law, that the concept of international law enforcement is a big question for us due to the many cases that could be enforced totally, and the others cannot be enforced. Let's see next. Next. Okay. It's very clear that international law disputes, settlement between states by judicial decisions is only one facet of the enormous problem of the maintenance of international peace and security that we face now. As I said before, that some of them are very clear, determined, and we regard as a real law. But many of them are not the real law. So what is maybe a positive morality? As one of the experts of international law, John Austin, said in the literature. So use of force under the United Nations Charter is impermissible. Peaceful settlement is the only available means under the UN Charter that the countries must solve the problems. The essential legal concept of Article 2 of UN Charter on dispute settlement formulates certain principles which bind both organizations and its members. Let's say all members shall settle their international disputes by peaceful means in a such manner that international peace and security and justice are not endangered. These provisions are very clear message for all the countries in the world. That means they must consider about the maintenance of peace and security. Did the League of Nations fail after the first war? And then we agree to build the new nation as successor of the League of Nations. And in today's problems, we face many problems are facing the countries, that is economic, political, and legal problems. Some problems are still going on under the supervisions of United Nations, especially the watch on United Nations Security Council. And the other problems are lost control. The United Nations Security Council, it seems, has no attentions to keep and maintain the peace and security at international level. This is just a concept that the UN Security Council have the main duties to maintain international peace and security. Next. If we say about the political case at international levels, it could be the interference toward domestic efforts of the other state, or about diplomatic issue just recent happened between United States and China. They made a persona non grata both sides for the diplomatic staff of China and China in US and US in China. Regarding with economic interests, let's see the territorial border delimitation of territory, land territory, and boundaries, and see the limitation between states, and about the owner of the islands or the lands. Next. If we see this chart, the chart of international law dispute settlement, There are two methods of settlements. The first one, peaceful means, and the other one, use of force. By peaceful means, the state can use negotiations, for example. For this case, there are many successful stories. Mediations also, even Indonesia, one of the states who succeeds as mediator between Cambodia war, between Vietnam and Cambodia. Litigations is through International Court of Justice that Indonesia also experienced in this case. We still remember the case Sipadan and Likitan Islands between Indonesia and Malaysia. Both countries brought this case to before the ICJ, and then the ICJ decided that the owner of these islands, Sipadan and Likitan, belong to Malaysia, and Indonesia accept regard this international, this the real law. And let's see the use of force as the last method to settle the problems of the international level and between two states. We still remember very clear about the Iraq invasion of Kuwait in the 1990s. There's the real big questions. This the real international law, that the provisions of international law, the provisions of the UN Charter can be enforced as soon as possible after the Iraq invaded Kuwait. Just in days after this deed done by the Iraq. And to this case, I would like to tell you about the very historic resolutions of the UN Security Council, number 677 of 1990. In the words of these resolutions, very clear. This is number 2. Is the second point of this resolution. Authorize member states cooperating with the government of Kuwait, unless Iraq on or before 15 January 1990 fully implement, as set forth in paragraph 1 above, the above mentioned resolutions, to use all necessary means, to uphold and implement Resolution 660 of 1990 and all subsequent relevant resolutions to restore international peace and security in the area. In these resolutions, I said that the United Nations Security Council have a very big interest to solve this problem as soon as possible, because this case, what the Iraqi military forces did, to real endanger the international peace and security in Kuwait and also in the neighboring countries. So the questions, why is United Nations led by the US has a very big interest to this case, not to the other state, not to the other case, I mean. Let's say between the case between Israel and Palestine until now. Please next. Next slide, please. Until now, for this Israel and Palestinian, the world, the United Nations, the US, the UN Security Council has done nothing. So many drafts of UN Security Council resolutions made by the permanent member of Security Council, but then came the veto of the US. This is very bad experience for us, especially for us as academicians, that international dispute settlement is live on concept only. International cannot be enforced like in national law, because in international, there is no specific provision stipulates on punishment against law violator. Let's see, in criminal code in every country in the world, every deed and every infringement, criminal offense did by somebody, by everyone, is clear stipulates the provisions that the sentence to death, for example, the sentence maximum 5 years in jail, etc. But in international law, we don't have these things. Second, there is no legal enforcers. We don't have public prosecutor. We don't have international police and international law. This exists only in national law. We have public prosecutor, we have police to enforce the law, and of course we have also, even though international law, we have also court. Now we have two, ICJ, International Court of Justice, and then we have International Criminal Court. And the third one, there is no the highest power to rule. There is no the highest power to rule. Secretary General of United Nations is not the highest power to rule all the countries, all the states in the world as members. He is only a regulator. He is not enforcer, legal enforcer, or law enforcer. But every country has the sovereignty. This is the highest one that every country has, that the other countries must respect this. If the sovereignty of the state is violated by the other state, it is of course a breach of international law. In this case, as I said before, I would say that international law is not the real law, but just positive morality. Exactly said by the John Austin as the expert of international law. And many cases show us about these facts. This is not the real law. Next, please. There were no sanctions imposed on Israel, even though for many times it violated international laws, especially peace and treaty. There were and there are no peace situations in Gaza, in Palestine. So many crimes are taking place in this area. And this case also endanger the neighboring countries, especially in Arabic countries. What we say about this? Where the sound of the UN, the Secretary General, the UN Security Council, they keep silence. Next. It's very interesting, it's very interesting to read the news in recent days. Peace treaty on 13 August, just weeks ago, 13 August 2020, between Israel and UEA. In this treaty, in short, I say, Israel agreed to suspend plans for annexing part of the West Bank. But what happened before? Let's say United States recognized the West Bank as the new capital of the Israel. This, of course, real violations of international law. Next. Yes, this is the main issue about the enforcement of international law before and now, and of course in the future. The veto right owned by the UN Security Permanent Members. Yes, that means the permanent member use the veto, and no, or abstain. In many cases, international law cannot be enforced due to veto right owned by one of the 5 permanent members of the UN Security Council. There are United States of America, China, Russia, UK, and France. Any of these 5 members use the veto, they will void the draft of resolutions.
I'm
This
sorry,
thing
Prof. Shafrin
take
Hadi.
place so many times.
I'm really sorry.
Okay, the last
because
the
time
last
is
slide.
very short. Thank you.
The last slide, maybe the last slide. Let's come to my conclusions. The enforcement of international law is primarily to aim to maintain international peace, security, and justice. That we are struggling day by day to uphold the international law so that the peace and security and justice be given can be distributed to all the countries in the world. Second, the world needs firm commitment of all members of the UN to comply with international law provisions. If any does not firm commitment, then it will endanger, of course, the international peace and security. The last one, the use of veto right by one of the permanent members of the UN Security Council should be guided by peace and security and justice principle, not on due to the economic interests or political interests of one state of them. Thank you. Thank you, Mbak Fatma.
Professor
Everybody.
Shafrin Hadi, for a very prominent and comprehensive explanation regarding the enforcement of international law. So I don't think I need to repeat the conclusion. Okay, let me stop the share screen. Okay. Ladies and gentlemen, thank you, Professor Shafrin Hadi, for a very comprehensive presentation regarding the enforcement of international law. So before we go on to the next speaker, I would like to inform all the participants who would like to ask questions for the speaker. You could leave your name in the chat box, and I will call your name in the Q&A session, and then you can go on to ask the question to the speakers. So with that, I would like to go on to our second speaker. We are honored to have Mr. Peter Zeng, who are currently at Washington, D.C. He is an associate of Polyhope LLP. Mr. Peter is a graduate of Yale Law School, where he twice received the Jerome Sayles Hess Prize awarded to the top student of international law. And Mr. Peter exclusively advises and represents countries on matters of public international law and international investment law. He regularly works on cases before the International Court of Justice, where he previously clerked, as well as before the International Tribunal for the Law of the Sea, the Permanent Court of Arbitration, and the International Center for settlement of investment dispute. So without further ado, I welcome Mr. Peter Zeng. The time is yours.
Hello, everyone. Thank you very much for that introduction, and thank you to the organizers for having invited me for this seminar. I also want to thank Professor Siar Fernaldi for an excellent first presentation to kick us off and set up the framework for the remainder of this event. As Fatma said, my name is Peter Zeng. I am a lawyer at the law firm of Foley Hoag, where I primarily represent countries, so diverse array of countries before the International Court of Justice on their cases. Now, I should emphasize that today I am not representing any particular country in front of all of you. I'm also not representing my law firm or the ICJ where I previously worked. I am speaking purely in a personal capacity, so I'd please request that no one quote anything I say, and also no one record or take screenshots of my presentation, simply because I'm actively litigating some cases before the court right now and would prefer to keep things safe. So without further ado, I should say I do have a PowerPoint as well, which I will share right now, and I hope that this will work. Let's see. Can someone confirm that they can see my slide?
Yes, Peter.
Perfect, thank you so much. And so I was asked today to speak about the enforcement of international law from a lawyer's perspective. But before I get into that, I'm going to start with a question. And that question is, let's see if I can get this slide to work. Does anyone know what this is? So okay, I think a lot of the participants are muted. I heard an island, but as Professor Siar Fernaldi had previously mentioned, this is Pulau Sipadan. I think all of us might be familiar with this island. It is off the eastern coast of Borneo. It's a very popular tourist destination, as many of you might know, and it's also home to some gorgeous sea turtles and other sea creatures. As some of you also might know, in October 1996, President Suharto and Prime Minister Mahathir decided to submit their dispute over sovereignty over this island, as well as Pulau Litigan, to the International Court of Justice for the resolution of the dispute. And as Professor Siar Fernaldi reminded us, in December 2002, the court decided by an overwhelming vote, 16-1, that sovereignty over these two islands belongs to Malaysia. This was obviously a crushing defeat for Indonesia. And what made it more crushing was the fact that the court relied on some very peculiar types of evidence, such as the fact that a predecessor to Malaysia's authorities on the island had issued regulations concerning the collection of eggs of sea turtles. That was indeed one of the key pieces of evidence showing that Malaysia allegedly had sovereignty over the two islands. So at the end of the day, what happened? Well, Indonesia was disappointed, of course, but accepted this judgment of the court. And I think a lot of us look back on this case and say, wow, this was a very weird decision, maybe even an incorrect decision. But I will say that from the Malaysian perspective, they will actually say that this is just an example of the enforcement of international law. In particular, what I will call in this presentation, adjudicatory enforcement. That is enforcing international law through international courts and tribunals. And from this one incident, we can piece together three different stages of the process. First, there's a submission of the case, of the dispute, to an international court or tribunal. Second, the court, in this case, the ICJ, adjudicates the dispute. And then finally, the losing state, in this case, complied with with the decision of the court. And this is effectively the enforcement of international law at work through an adjudicatory mechanism. Now, for the remainder of my presentation, I want to convey one simple message, which is that this adjudicatory enforcement mechanism has many, many, many limitations. I would not go so far as Professor Siar Fernaldi and say that international law is not real law and it's just some positive moral authority. I would say it is real law, but I accept the fact that when it comes to enforcement of international law, there are severe limitations. And when it comes to these three categories we see right here, I think most people think primarily of compliance. They say when you have a decision of an international court or tribunal, you can't force a country to comply. In my view, that's actually one of the less significant limitations of this enforcement mechanism. And actually, there's some limitations also present in the first and second stages, submission and adjudication. And so I'm going to proceed through these three stages, one after another. And so we'll start with the first one, the submission. And this, I would posit, is the single greatest limitation to the enforcement of international law through adjudication, namely the principle of consent. Now, I think we're probably all familiar with this, but just to be sure, the principle of consent provides that an international court or tribunal can adjudicate a dispute only if all the parties to the dispute agree. Only if all the parties to the dispute agree. So in the case of Pulau Litigan and Pulau Sipadan, of course, we had the agreement of both Malaysia and Indonesia to submit it to the court. But the reality is this is very rare. Usually, if there's one country who's probably violating international law and is accused of violating international law, they're not going to agree to submit any dispute over that violation to an international court because they think that they will lose. And as a result, there's no jurisdiction, there's no possibility for the court or tribunal to rule on the matter. Now, there are what we call compromissory clauses in treaties. Now, these are clauses that effectively give jurisdiction for a court or tribunal to decide a dispute ahead of time. So one very famous example is Article 286 of the UN Convention on the Law of the Sea, UNCLOS, which states any dispute concerning the interpretation or application of this convention shall be submitted at the request of any party to this dispute to, and I'm simplifying here, an arbitral tribunal. And this was indeed the provision that was invoked in the famous Philippines-China arbitration, where my law firm was representing the Philippines. Now, the reality is these compromissory clauses in treaties are very rare. They exist in far fewer than 1% of treaties. So what that means is that when one country violates a treaty that's signed, 99.9 or even more % of the time, there's still no way to bring that country to an international court or tribunal without that country agreeing. And that is the principle of consent at work. That is the principal reason why adjudicatory enforcement is really not that effective in resolving international disputes. And think of some of the biggest disputes today. The war in Yemen, for example, the Kashmir conflict between Pakistan and India, or even closer, looking at the Mekong River dispute between China and various Southeast Asian countries. All of these disputes are cases where a country would like to bring another country to an international court or tribunal for adjudication, but the problem is that there is no agreement by that other country to submit the dispute, and as a result, this mechanism cannot operate. And even if you get the consent of all the parties to a dispute, it's also a very political decision whether a state wants to bring another state to an international court or tribunal. Think, for example, of the recent conflicts over the past year in the Natuna Sea. There have, of course, been issues with Chinese Coast Guard vessels near the waters of Indonesia. Here, there actually is a jurisdictional basis for bringing a claim. Indonesia could sue China before an arbitral tribunal, just based on the same basis as Philippines did against China under the Law of the Sea Convention. Both Indonesia and China are parties. But the political repercussions of Indonesia bringing a case against China would, I think many of us can imagine, be quite significant. And that in and of itself also prohibits a lot of states from pursuing this sort of mechanism. And I should say, in my own practice, we deal with this sort of situation a lot. Many countries come to us and they say, we're interested in suing another country. Please analyze the case for us. What are our chances of winning? But at the end of the day, they still decide not to pursue it simply because there are a lot of politics involved. Now, that's all I was going to say about this first stage of the process. I would be happy to go into more detail in the question and answer, but for reasons of time, I'm going to move on to the second stage, which is the adjudicatory phase. And here, you would think that international law is purely at play and being applied because you're arguing cases before a court or a tribunal. But the reality is, and please don't quote me on this because I cannot be recorded to have been said this, but the reality is there are a lot of other non-legal considerations that might go into that might come into play when a court is making a decision. One, there can be political issues. One famous example is the recent case brought by the Marshall Islands against India, Pakistan, and the United Kingdom over their nuclear weapons capacities. The court ultimately decided 9-7 that it did not have jurisdiction, that is, it could not hear the dispute, that is ruling against the Marshall Islands. What's interesting though, is that if you look at the identity of the 9 judges that voted against the Marshall Islands, they all had something in common. We had Judge Judge Rani Abraham from France, Judge Hisashi Owada from Japan, Judge Peter Tamka from Slovakia, Judge Chris Greenwood from the UK, Judge Xue Hanqing from China, Judge Donahue from the US, Judge Gaia from Italy, Judge Bandari from India, Judge Gevorgian from Russia. All of these judges just happen to be judges from countries with nuclear weapons or under the umbrella of allies with nuclear weapons, under the nuclear umbrella of allies with nuclear weapons. And so when one looks at this sort of case, one thinks, were these judges really deciding on the basis of law or just based on their own national interests? I will let you answer that question on your own. Another common critique of international courts and tribunals are Solomonic decisions. The idea is that a court might want to render a decision that would be even between the two countries, that would kind of split the baby so that there would be a greater chance of compliance. One great example of this is the Pedro Branca dispute, which is also close to home in Indonesia. This was between Malaysia and Singapore. The court had to decide sovereignty over 3 features: Pedro Branca, Middle Rocks, and South Ledge. What did it do? It gave Pedro Branca to Singapore. It gave Middle Rocks to Malaysia. And then South Ledge, it said it didn't have the jurisdiction to decide that matter for some complicated reasons. And that was it. And the final point I want to make here is not something you hear commonly, not something you see in the literature, but I would also posit that adjudicators often want to minimize disputes, and that sometimes interferes with their prerogative to adjudicate on the basis of international law. So as an example here, I want to draw our attention to this feature, which some of you might recognize. This is Itu Aba, Taiping Dao in Mandarin. It is located in the Spratly Islands, right about here in the South China Sea. And this was one of the major features in dispute in the famous Philippines-China arbitration. And I think some of you are familiar with this arbitration. The big question here was, is this an island or a rock? Why does it matter? Well, under the UN Convention on the Law of the Sea, which we saw before, if it's a rock, it gets this 12 nautical mile territorial sea, around that size in this red circle we see on the screen. If it's an island, then it gets an additional 200 nautical mile exclusive economic zone. That's a pretty big difference. We have a rock here, an island here. Now, the tribunal was not supposed to decide who had sovereignty over this feature, but it did have to decide whether it was a rock or an island. And one consideration that could have been going through the tribunal's mind is, well, if it's a rock, then what the parties are really disputing, Philippines and China, is just this small area. This might decrease the chance of conflict in the future if really their dispute is limited to this area. If it's an island, then their dispute is actually this big. And so what that means is there's greater chance of conflict because it's such an important feature for both countries. And so one potential consideration that goes into the mind of adjudicators, in my view, is that they sometimes consider which option would minimize disputes the most. So while this may be praiseworthy, it might be a worthy cause, it is not really adjudicating on the basis of international law.
Mr. Peter,
That's all.
I'm sorry
Yes.
to cut. Yeah, the time is already 15 minutes.
Okay, I have 14 minutes on my watch. Do you mind if I spend 2 more minutes on the last phase?
Okay, that's okay. I think we have different time as well in the timer. I'm sorry.
Thanks very much.
Yeah.
So the third phase is compliance, and I'll try to speed through this one in view of the time. So we do know that technically international court and tribunal decisions are binding. We see that in Article 94 of the UN Charter, which I won't have to read for all of you. The big counterexamples are of course, Nicaragua versus United States, Philippines, China, even the Chagos advisory opinion of last year. And I think this makes a lot of people think that international court and tribunal decisions are not binding. But if you look at the statistics, actually 95% of cases between countries are complied with. 95%. It's really only those 5% with these big, powerful countries where you don't get standard compliance. And so with a 95% compliance rate, in my view, the issue of compliance with international judgments is not actually that big of an issue. Yes, it's not 100%, but 95% is quite significant. There are many reasons that have been put out there in the literature for why states comply. And in view of the time, I'm not going to go into all of them in detail. But the reality is, even without a police force forcing a country to comply with the decision, 95% of the time, countries do comply. And that does show that international law, at least in the form of an adjudicatory mechanism, does have a lot of force. So at the end of the day, why did Indonesia accept the Pulau Litigan and Pulau Sipadan judgment? I'm not privy to any secret information, but there are many hypotheses that have been put forward. I mean, it's particularly curious that it would accept this decision on the basis of such strange reasoning, on the basis of regulations for collecting eggs of sea turtles. But in any case, in my view, the more interesting question is, why did Indonesia agree to submit the case to the court in the first place? Because at least in my practice, for all the countries that we work with that submit disputes to courts, they always make sure to ask us to provide a full analysis of the case in advance so they know what their chances of success are. And with a decision like 16-1 in the Pulau Litigan case, the question is whether Indonesia should have expected to have lost the case or not. I will leave all these questions up for your thoughts and for the question and answer session. And I very much thank you all for your time. And I look forward to the remaining presentations.
Thank you, Mr. Peter, for a very interesting explanation and insight in the more practical side of the enforcement of international law. Thank you so much. Ladies and gentlemen, we are going to continue our panel session for today. Our third speaker, I would like to welcome Mr. Febrian Alfianto Rudriat. Mr. Rudriat attained his bachelor degree at Universitas Padjadjaran in International Relations and master's degree at the University of Birmingham in International Studies or Diplomacy. He was a political counselor for international peace and security and disarmament for the Indonesian permanent mission to the UN in 2007 until 2010. And he served as he was the deputy chief of mission at the Embassy of the Republic of Indonesia in Vienna, Austria in 2015 until 2017. And currently he served as the Director General for multilateral cooperation at the Ministry of Foreign Affairs. So without further ado, Mr. Febrian Alfianto Rudriat, the time is yours for 15 until 20 minutes.
Well, thank you very much, Ma Fatma, for giving me the screen, not the floor. And first of all, I would like to greet to all the previous speaker, and thank you so much for the insight that has been shared with us. And I have to make one confession that I'm not so I don't have a legal basis whatsoever, legal background in my study. So I will speaking from the views of the so-called international relation practitioner rather than the international legal. So forgive this crowd, but I hope that Scott is also have the same background with me as an international practitioner rather than international lawyer or international legal expert. So I believe this gathering has a very fine balance between the lawyer and international relation practitioner. Let me start by I confirm my action to ISIL. Sometimes I not to live to left the L. So it's L for organizing this virtual seminar, and I believe this seminar will contribute significantly to our effort in developing national legal system, especially in implementing international law. I also this topic is to the current situation, especially related to Indonesian current non-permanent membership in the United Nations Security Council. Today, we will discuss about the importance of establishing a national legal framework and implementing UN Security Council resolution. And I would like to present my thought in a three major points as follows. First, I would like to have a highlight some of the nation role as members of the UN Security Council. I would like issue and challenges related to the implementation of United Nations Security Council resolution at domestic level. And last but not least, I would like to address the importance of having an act to support the implementation of United Nations Security Council resolution in national legal system. My colleague, I think this year will be second and also the last year Indonesia non-permanent membership SC for 2019-2020 period. And during the last 1.5 years, we have served as one of the US NACI-related member, which is representing Asia-Pacific region. We have some priorities, which I mentioned before so many times, namely 4+1 priorities, which is the first is creating ecosystem for peace through promoting dialogue and strengthening peacekeeping and peace-building mission. And a second pillar, second priority is strengthening cooperation in counterterrorism. Third priority, making strong connection between peace building and sustainable development. And the fourth priority is strengthening partnership between UN and regional and sub-regional organizations. This kind of issue, the last issue, which is partnership between UN and regional organizations, and somehow will contribute positively to the implementation of United Nations Security Council resolution. And last but not least, also Indonesia has put much attention to the Palestinian issue, which is we consider as one of our constitutional mandate issue in our constitutional mandate. We also have served as chairs of several sanction committee, namely 1267 regard to ISIL with 1L, Al Qaeda, and Committee 1540 on non-proliferation, and then the 1988 resolution committee on Taliban. So this is embodied the implementation of the international law. If you consider that UN Security Council resolution is one of the source of international law, and of course now we also hold the position as the pen holder for Afghanistan and Palestine issue. Pen holdership is a new method, relatively new method for the last 5 years, where non-elect on P5 member of Security Council has more role in bringing the issue in the discussion of Security Council. So this is the thing that I would like to share with you. And of course, during our membership, we have many things that we have accomplished. And of course, during the current presidency, and our presidency will be last until the end of August, we will bring the main theme of advancing sustainable peace. And also the theme has aimed to strengthen global solidarity to face the new security challenges in time of the pandemic. We also have organized 2 virtual general debate, open debate on counterterrorism and the link between peace building and pandemic. And last but not least, I think we are looking forward to organize ARIA Formula, a format meeting on cyber attack on civilian infrastructure, which will take place on the 26th of August. So these are the things that I would like to share with you with regard to our membership in permanent in Security Council. So the issue now that I would like to discuss with you, colleague, is the challenges related to the implementation of the UN Security Council resolution in domestic level. Before moving to the second point of my presentation, I would like to highlight the unique characteristic of Security Council, UN Security Council. To enforce peace and security, Security Council is entitled to use coercive measure based on UN Charter, which is military action or sanction. So this is the tool that exclusively owned by Security Council. You cannot find this kind of tools in other international organizations, let alone other international mechanism. So, however, the term of sanction is not explicitly written in the UN Charter. So it refers to several types of activities with, if I may say, first is arm embargo. Second, travel ban. Third, asset freezing. Fourth, commodities ban, like raw material, mining production, etc. Transportation bans, diplomatic restriction, bans on proliferation on sensitive goods, and last but not least is financial restriction. So these kind of activities that consensually been agreed in Security Council to be considered as the so-called sanction. And of course, Indonesia, as a matter of policy, it's a sour policy that we only recognize UN sanction, not unilateral sanction. In many discussions in Security Council, we always reiterate this position that sanction is the last resort, should be targeted, and should be reviewed regularly and not permanent. So everything is subject to change. So does the attitude of the state. So having this principle, I think it's very clear. The Indonesian principle, we always mentioning again and again in Security Council, is very important. It's become one of our pillar for multilateralism diplomacy. For your information, there are around 30 sanction regime of the United Nations Security Council since 1966. So no 30 sanction regime since 1966, and currently there are around 14 active regime and 10 monitoring team or monitoring group or monitoring panel which related to this sanction. And of course, the UN sanction regime has several objectives, which is first is to achieve conflict resolution. Second, for the purpose of non-proliferation of WMD or weapon of mass destruction, support the effort of counterterrorism, to achieve democratization, and last but not least, the most important thing I think is to provide the protection of civilians. So these are the things that they're supposed to be, and ideally has to be the objective of the UN sanction. And of course, the implementation of the sanction is not short of challenges when we try to implement the security resolution. For example, we is committed to implement United Nations Security Council resolution. However, we do not have a more specific and comprehensive legal framework to support the implementation. We note some challenges in implementing the UN, the Security Council resolution. For example, one, the object of sanction regime could be country-specific and targeting entities and individuals. This is within the Indonesian life, which is now it's become a democratic life. We have a different way of life compared with 15 or 20 years ago. It's become a challenge for us. Secondly, immediate implementation of the sanction is required. So there's no such thing as definition of immediate. It's something which is concept immediate, never be able to be consensually agreed. If you talk about immediate, how long does it take? One times 24 hours, 2 times 24 hours, or in the minute, whatever it is. I think this quite bring us a challenge how to interpret the immediate implementation, because when we have to implement, we have to following the legal procedure that we have that exists in our legal system. So this again challenge for the democratic country to implement the United Security Council resolution. Third is also there is a possible that sanction comes because of referral from multilateral regional forum, which is we are not part of that multilateral or regional forum. So all of these things has been challenged to us whenever we have to implement the Security Council resolution. The current implementation of some Security Council resolution are based on specific and separate national legislation. For example, such as anti-terrorism law, anti-money laundering law, and nuclear and chemical substance law. So there's no such thing as the umbrella as that that enable the Indonesian government to be able to address the implementation of Security Council by having one umbrella of rule or law. I think it's make us easier and more efficient and effective in terms of implementation for us to be able to implement this Security Council. So these are the things that become our challenges in whenever we have to implement the Security Council resolution. There are several United Nations Security Council resolutions on terrorism that already implemented nationally. For example, Security Council Resolution 1267, UN Security Council Resolution 1988 and 1989, and United Nations Security Council 2253. These are the Security Council resolution that we already implemented nationally because we have the legal foundation, the legal basis, the law that make us enable to do that. And implementing Security Council resolution to counter terrorism, we could use, Indonesia used some national legislation as a legal ground. For example, like Counterterrorism Act number 15, 2003, and Anti-Terrorism Financing Act number 9, year 2015. And joint decree between MFA, Ministry of Foreign Affairs, Supreme Court, National Police, and Anti-Terrorism Agency, and the Financial Intelligence Unit. We can use this joint decree between the minister. And of course, FATF recommendation also become a legal ground for us to implementing a Security Council resolution. And in implementing Security Council resolution related to non-proliferation of weapon of mass destruction, we also has used some national legal framework as follow. For example, decree of PPATK, which is the Financial Intelligence Unit of Indonesia, Ministers of Law and Human Rights Regulation, joint decree between MFA, Police and National Nuclear Energy, as well as there are two non-proliferation sanction regime, which is Iran and North Korea. These are the legal foundation that we use so far in addressing this particular issue. There are also several sanction regime related to post-conflict countries like Sudan, South Sudan, Somalia, and Central African Republic. Those regulations are not yet effective and not yet comprehensive and have not strong legal basis. So this is, in fact, is our homework. And I would like to take the moment of becoming the member of Security Council within 2 years, the last 2 years, to give us a more understanding, more stepping stone, or to create more awareness for us, not only Minister of Foreign Affairs, to let's work together to make a one umbrella regulation or law that be able to serve as our tool to implement the Security Council relation, which is one of source of international law, more effectively and efficiently. Urgency to have UN Act is very pertinent, and I think it is the right time to develop legal system that can support the implementation of UNSC relation and at the domestic level. The characteristic of Security Council resolution is legally binding for all UN membership, Chapter 7 of the UN Charter. And in implementing UN Security Council resolution, the member states have different methods. One of the method is through a UN Act. As I mentioned earlier, currently there's no specific legal frameworks with the implementation of Security Council resolution under the Indonesian national law. And this will lead into legal uncertainty in the implementation level. The UN Act is generally a piece of legislation which is specifically designed to allow for the transformation of measures under the resolution into domestic legal framework. Other methods are through the pre-existing regulation that is not designed to implement sanction, and through an ad hoc legislation and respond to specific resolution and situation. As our note, some countries already have related legal framework or UN acts, such as Singapore, USA, Australia, Netherlands, and Japan. And we have carefully studied the UN Act implemented in some countries with a view to develop our own UN Act in the near future. Colleague, I think to conclude my presentation, Indonesia non-permanent membership in the UNSC can become a momentum to establish UN Act. UN Act will help us to balance between the upholding of national interests and the implementation of international obligation. For your information on current development, in 2019, the draft of UN Act and its academic paper have been prepared in cooperation between Ministry of Foreign Affairs and the Faculty of Law, University of Indonesia. And I hope that my short remark will share some views and knowledge about the importance of having UN Act to implement Security Council resolution. And I really do hope that we could discuss further the detail of this issue. I thank you, Mbak Fatma, and I leave the screen to you. Thank you so much.
Thank you, Mr. Fabian Rediat, for a very insightful presentation or explanation regarding Indonesia's practice in enforcing international law at the national level, and specifically in Indonesia's stand on the implementation of UN Security Council resolution. So thank you, Mr. Rediat. So ladies and gentlemen, for the last but certainly not least speaker, I would like to welcome Mr. Scott Thomas Bruce. He is the Foreign Affairs Officer in the Office of Counter-Proliferation Initiatives in the State Department's Bureau of International Security and Non-Proliferation, United States. And prior to working at CPI, he was a team chief in the Office of Cooperative Threat Reduction, where he leveraged U.S. foreign assistance to support non-proliferation programs. Prior to joining the State Department, Mr. Scott was a POSCO fellow at the East-West Center, and he supported programs on non-proliferation and international security at a variety of different research institutes. So without further ado, Mr. Scott Thomas Bruce, the time is yours.
Good morning, and thank you very much for having me. It's a great pleasure to be here and address this group. I think this has already been a very productive conversation, and I've learned a lot hearing the words of the former speakers. So it's a great pleasure to be here. Like Director General Fabian, I am not a lawyer and will not represent myself as one. Rather, I am a foreign affairs officer in the Office of Counterproliferation Initiatives in the State Department's Bureau of International Security and Nonproliferation. In that capacity, I work with partner governments to be able to provide some of the tools and resources to help them fully implement various United Nations Security Council resolutions, or UNSCRs. And this allows them to support those UNSCRs, fulfill their obligations against countries like North Korea and others. So today I want to focus on the types of tools and resources that we provide to foreign partners that allow them to be able to help enforce those sanctions effectively. I won't be able to discuss in depth the specifics of the various legal authorities that come into play. Again, that's not my area of expertise, but I'm very happy to answer any questions that may arise to the best of my ability in the course of that. I think the key point is one that the Director General made here, which is that UNSCRs are not self-implementing. They require different processes to be able to come into place to be enforced, as well as different measures to ensure that institutions within a jurisdiction comply with the elements of those UN Security Council resolutions. That's part of why my office works very closely with foreign partners to develop and share tools that can help them effectively implement as well as enforce those measures. And so with that in mind, I'm going to provide an overview of two of those tools that we have developed and how they work. Because most of my work principally focuses on North Korea or the DPRK, my examples are going to center on that country, but the type of tools that I'm discussing exist in many other contexts and can be leveraged for a variety of other different UNSCRs as well. I think it's also worth noting that while my role is particularly focused on sanctions enforcement with regard to North Korea, there are other elements of the State Department and our government that are very much focused on resuming negotiations with North Korea. And so while I talk about some of the sanctions measures, it's worth noting that we very much still hope to resolve the global security threat posed by North Korea's ballistic missile and nuclear programs through those mechanisms as well. Our sanctions efforts support those diplomatic efforts by signaling to the DPRK that negotiations, rather than broad provocations or sanctions evasion efforts, are the only clear path to their long-term goals of economic development and security. So with that said, maybe I can talk about some of the tools we've provided to partners that can help them understand and enforce UN Security Council resolutions. And the first that I'll call your attention to is what's called the Global Shipping Advisory. This was published in May of this year. It's a publication that is joint from the State Department, the Department of the Treasury, and the Department of the Coast Guard. And it goes into a variety of details about different sanctions regimes and how they impact the maritime industry. It's got 3 different parts. The first is an overview of some of the global sanctions evasion activity that a variety of different players, including North Korea, do. And then it follows up with a set of industry-specific guidance on how to comply with them to be able to make sure that you're in line with those sanctions, noting that the measures that different groups will have to take, whether it's a ship registry or a port authority or a financial institution or a ship owner, are going to be different. And we want to make sure that all of these different groups have the right tools and knowledge available so that they can make sure that they're fully in compliance with these sanctions. The third part goes into specific details. For example, there's very specific measures on what sanctions there are against North Korea and what those look like, what sections of the economy and goods are specifically sanctioned by the UN. Again, providing detailed information on the context of a variety of very complicated UN Security Council resolutions to be able to ensure that partners understand them and can enforce and comply with them. Now, since its publication, we have translated that document into more than 12 languages. And we've been sharing it with our partners around the world, making sure that it's available to them in their language they understand. We'll do outreach to be able to talk about its contents. We'll also do outreach to key members of industry to make sure that they understand what it includes. Since a big part of the advisory are specific measures for different parts of the industry, we will often work with that industry internationally in individual countries, as well as some of the international associations associated with that industry, to be able to make sure they know some of the specific provisions that are involved. For example, working with the insurance market to be able to ensure that insurers understand the role of marine insurance as it relates to sanctions enforcement. As a result of this, we've seen very positive feedback. We've seen industry associations develop circulars to be able to specifically outline the punitive measures that members of their industry will face if they don't take action. We've seen states be able to adopt and levy fines that specifically address elements of the advisory, specifically fining individuals or entities for utilizing some of the common sanctions evasion practices that were outlined in that advisory. We've also seen other groups, for example, ship registries, respond to requests in that initiative to develop an information sharing mechanism between different states to be able to share information on sanctioned vessels traveling internationally. Not through our work, but through the initiative of these states in following up with this advisory, you saw an organization formed that covers more than 40% of the gross tonnage of global marine traffic that has started to share information between them about sanctioned vehicles in order to prevent these vessels from hopping from registry to registry. And so far, that's shared the names and information of more than 120 different vessels that have been involved in various sanctions evasion activity internationally. So that's one of the tools that I would like to talk about. I think there's another tool that the UN offers that is really important to focus on. And these are the works of the various UN committees panel of experts groups. Now, these are panels that go and do investigations of measures that are seen in violation of those different sanctions. So in my area, in North Korea, there's the UN 1718 Committee Panel of Experts, or POE. This panel publishes reports twice a year, usually an interim and a final report. And this report shows the panel's investigation over the last period of a variety of different sanctions evasion activity that has gone on pursuant to the UN Security Council resolution that they are responsible to. So the last report was published in April 2020. There should be another report coming out in the next few weeks. In that report, the POE documented how North Korea's illicit activity relies on ports in East and Southeast Asia to do things like obscure the source of that of their commodities. So it may appear to come from one state when really that is a fraudulent documentation that is masking the fact that it's a sanctioned commodity that has come from North Korea at some point. The POE's investigations revealed that the DPRK continues to import refined petroleum through ship-to-ship transfers. These are movement of transfers of petroleum at sea from ships to ship with foreign flag vessels. It's worth noting that these ship-to-ship transfers of any commodity with a North Korea vessel is a violation of UN Security Council resolutions. So these transactions are obviously a serious concern to the United States, as refined petroleum sales to North Korea above the cap set by the Council undermine the UN sanctions regime. They make the whole UN sanction system less enforceable. So the report notes that some vessels conducting these direct deliveries changed ownership prior to their activities. And this is a key red flag report outlined about what you can do to detect what some of these vessels do. They're often moving from registry to registry in advance. So it also mentioned that a lot of this illicit trade exhibits evasion patterns, including indirect routing, detours, and other activities to disguise the source of the commodity. So part of what we do in response has been to take this cable, share it with all of our foreign partners, talk to them about the entities of concern that are in their jurisdiction so they can take action in line with their UN obligations, and give them a list of all the entities that they should have on various watch lists to be able to ensure that they are not exploited by the North Korea or others. Our expectation is that helpful resources like the POE report will allow our partners to detect vessels that are flying under false flags or otherwise engaged in illicit activity. So these are just two of the examples of what we do. We believe that everyone has a shared interest in enforcing these UN Security Council resolutions. And as part of the State Department's diplomatic mission, part of what we want to do is be able to share the tools that can help those partners better enforce those measures and comply with them. And with that, I'm happy to cede the floor and let any questions that are out there move forward. Thank you very much.
Okay, thank you. Thank you, Mr. Scott Thomas Bruce, for a very insightful explanation regarding the stand of the United States on the enforcement of international law. So I think we already come to question and answer station. I already note several questions that have been sent to me privately. But before that, I would like to invite Miss Kusrianti, PhD from Universitas Airlangga. She already sent the question in the chat box, but I would like to invite you to ask your question directly to the speaker. If you may unmute your, okay.
Yeah, thank you.
Please.
Yeah. My question, the first question is for Prof. Safri Nardi. You said that international law is not law, it's only positive morality. Concerning the a statement or in your presentation, actually, practically we saw the international law, many international law is work as a law. And as like Peter said that 95% international law is implemented. So I challenge the statement that international law is not law. I think that's true if only we see it we see international law from the positivist side. That's question for Prof. Safri Naldi. Can I continue with the second question to the second speaker?
Yeah.
Okay. My second question is for Mr. Peter Tseng. In your presentation, you said you give an example that the Coast Guard China Coast Guard was in Indonesian water. Would you please explain us, is there any legal firm legal basis in the UN clause or in other international legal document that Indonesia can bring this case to international tribunal, or maybe in bring this case to International Court of Justice? And that's for my second question. Can I continue?
Okay, that's okay.
Yeah, I actually have a 3 questions
Okay.
so far. And the third for Bapak Febrian. Based on your experience as the negotiator or as a representative, Indonesian representative in as a non-member, non-permanent member Security Council, is there any international sanction to protect civilian that implemented effectively and efficiently in other countries? Thank you. That's all my question. Thank you, Bu Fatma.
That's a question from Mrs. Kusrianti. I think before all the speaker answer the question, I would like to invite the second participant who would like to ask question, Ms. Rika Kurniati from UB. If you may unmute your mic so that you could ask the question directly.
Okay, thank you, Mbak Fatma. My question goes to Pak Febrian, so I directly ask to Pak Febrian, based on your experience and your expertise, I would like to ask you about what is the best practice in implementing the UN Security Council in the national legal system, because you said that we have to immediate apply the Security Council to the national level. So that my first questions, and then the second question is, sometimes the international security interests are different to the national interests. So how to balance those interests? Thank you.
Okay, thank you, Ms. Rika, for the question. I think this is, I will close the first session of the question and answer. So I would like to invite Prof. Syafrinaldi, who would like to answer the first question from Mrs. Kusrianti. Please, Prof. Prof. Syafrinaldi, if you may unmute your mic, please.
Okay. Thank you, Ibu Kusrianti, for the questions. I said that partly of the international law is not the real law in terms of the enforcement of the law. But the others are the real international, they are law. Sorry. There are war aircraft exercising in the air of my city. It takes place every day, day and evening, in the morning and evening. Sorry. Yeah. To some cases, I said that there's not the real law. It's just positive morality. If a country has a positive morality, this the good morality that it has, but some of them are the real law. Even the enforcement of the international law in such cases are very soon and very clear and very forceful, like Iraq case. In many cases also, they are not the real law. They are only the economical, political, and legal interests of some states or certain states like US and other countries. So Bu Kusrianti, this is not totally, I said that international is not the real law, it's just positive morality in some cases. I agree that this is international law, but the law, the international law is not like in national law because they don't have the legal enforcers like in our national law. They don't have police, international police, they don't have public prosecutor like we have in a national law in Indonesia and in every country. Thank you.
Okay, thank you, Professor Rinaldi, for the answer. I think I will go on to the second question for Mr. Peter Zheng regarding the China Coast Guard in Indonesian waters.
Yep, thank you very much, Professor Kusrianti. I hope I'm pronouncing that right, for your question. I think it's a very valid and a very interesting question. I do want to make sure, as Arya promised me, that this is not being recorded because although it's a very simple question, I just can't risk anything given some active cases I'm involved in. There were two questions, effectively. First, can this issue be brought to the ICJ? Second, can this be brought to another tribunal? For the ICJ, the answer is no. And the simple reason is that there is no prior agreement, consent of the parties to do so. Now, if Indonesia and China were both to agree to bring it to the ICJ, yes, they can. But if they don't agree, then that can't happen. Indonesia cannot do it unilaterally. The second option for an arbitral tribunal, it is indeed possible, as I was hinting at during my presentation there, because Indonesia and China have both consented to arbitration under the UN Convention on the Law of the Sea. Now, of course, things are always more complicated than they at first seem, particularly when it comes to law. So there are actually, as you might be aware, two articles in UNCLOS 297 and 298 that provide exceptions to jurisdiction. And so China, of course, would try to say that this case of its military vessels falls under one of these exceptions. I don't want to go into too many details here, but what I will say is that yes, Indonesia could formulate a claim that gets around those exceptions in Articles 297 and 298, and thereby allow Indonesia to bring a claim against China before an arbitral tribunal, just as the Philippines did against China on the same legal basis. But of course, whether that's actually a good idea politically is a completely different question. I hope I've answered your question enough.
Okay, thank you, Mr. Peter, for the answer. And then for the third question, that is for Mr. Febrian. The last question regarding the Indonesian contribution for the implementation of international law regarding the UN Security Council resolution. If you may unmute your speaker to answer the question, please.
Thank you. Thank you, Mbak Fatma. Thank you, Bu Rati. Okay, Bu. Your third question with regard to how is there any Security Council resolution which successfully implemented with regard to protection of civilians? If that is the question, right, Bu Rika? Just to make sure that it's right question from you. So it's about the implementation.
Yeah, okay. Pak.
So, as I mentioned in my previous presentation, the objective of UN sanction is one of the objectives of UN sanction is to guarantee the protection of civilian. And we have so many cases, we have so many examples where UN sanction or UN resolution also address the civilian protection. Like if you see the most of the UN Security Council resolution dealing with the conflict area, like in Sudan and many countries in Africa, it always has the element of protection of civilian, and it always has been conducted successfully. I'm not trying to evaluate, to give the what you call it, to give the assessment whether it is successful or not, but at least it was implemented. So many peacekeeping operation was sent under this resolution. So it means that yes, the implementation of the principle of protection civilian has been done in UN Security Council. Yes, it has been sent a peacekeeping operation with one of the mandate is to do the protection of civilian. So it's not necessarily that this protection of civilian done under the legal national framework, but it also could be done within the framework of international cooperation by sending a peacekeeping operation. So, Bu, yes, the answer is yes. And we have seen so many UN Security Council resolution which conducted based on this piece of protection of civilian. You know, most of in the conflict countries, conflict areas, which UN Security Council resolution addressing is always has an element of protection of civilian. The main reason why UN sent the peacekeeping operation is to make sure that the civilian are protected and the conflict are not prolonged, and if possible, we'll be able to make the conflict areas are being addressed and the conflict has receded. That's my answer. Coba.
Thank you, Asih.
Sorry. Thank you, Pak Febrian, for your answer. I think in the chat box there is no any more question, but there are several questions that is sent to me privately. So I would like to.
I'm sorry, Bu Fatma.
Yes.
Actually, I haven't get my question answered by Pak Febrian.
Oh, I'm sorry. Bu Rika ya. Okay, Pak Febrian, I'm sorry. There is one more question from Bu Rika Kurniati. If I may read it myself in the chat box. What is the best practice in implementing UN Security Council resolution in the national legal system so that it does not violate the country sovereignty? And the second question is, yeah, international security and national interests are sometimes different, and how to balance these interests. So, Pak Febrian.
Thank you. Yes, I just about to mention this, but because I think we want to finish the third question. Okay, there are two questions from Bu Rika. First is how to nationally implement it United Nations Security Council resolution when there is no such thing as the UN Act or the umbrella law for us to be able to do that. Of course, first, if there's a UN Security Council resolution that need to be implemented nationally, what we are doing now is do the scanning for all possible legal basis that we could use to be able to implement this Security Council resolution. I have a couple of cases that I've been mentioning before with regard to how we're going to proceed with that. We have law on counterterrorism, we have law on many things, but how if there's no such thing as a law that can be used? So what we are doing usually is have a coordinated meeting among the line institution, among the technical institution like police, PPATK, or any other institution that we consider necessary, and at the highest level produce such thing like a joint decree or joint regulation by the concerned ministry to fill up the gap where the basis of the law is not available. So by having this, and we have so many time doing that, we can address but it's still in the ad hoc basis. But at least we can do something to implement the Security Council resolution, because this is our obligation to implement it. But what I'm trying to say now is trying to create a more systemic and a more sustainable legal basis that we can use. What we are doing now is, in fact, it's only filling the gap, and it's on an ad hoc basis. And I think it's not healthy as the country which uphold the principle of law. So this is the job for us now, all of us, and maybe specifically the member of ISILL with double L, to try to do our best to make sure that we will have a UN Act as when we are not, because if we are not in the Security Council, thing will be much more difficult. The what you call it, the awareness of the people, of the public, to the issue of Security Council is not that high. So while we are in the council, I think we should have beat the iron while it's hot. So I think so it's high time for us to do that. Secondly, on the balance, to balance the nature of interest within our national interest, and how for us the necessity for us to implement the Security Council. It's always become the challenges, Bu Rika. It's always become the challenges, and we cannot have a general or generalized or generic answer on that. We have to see it case by case. But if you ask me personally, so it's nothing to do with my formal position, but as a Fabrian, as the international relation observer, I think at least there are three ways how we can judge our or balance our interests when we have to implement the National Security Council. First, if the decision, if the resolution has a legal basis in our domestic legal system, I think we have to implement that. So it means that it's in line with our interests. As long as it has a legal basis in our national legal system, I can guarantee it is in line with our interests. Secondly, if we don't have legal basis in our system, then we can, on our discretion, make a decision whether we're going to implement that or just to ignore that, because we don't have any national legal system. We don't have any legal basis for us to do that. So hypothetically, when there's no legal basis, it is not clear whether these decisions are in line with our interests or national interests or not. So in that case, we have to see it case by case, whether it will bring harm to our interests or it will not bring harm to our interests. So it's really a prerogative for us to be able to say whether, okay, we will do it, or just ignore it. Many countries do that. Maybe Pak Scott can answer me, can give some explanation when they are ignoring that. So if the third is the most, what you call it, is the most contrasting, is the most different thing, is if the decision of the council against your very national interest or against your interest as a country, not only the territorial integrity, but also the existence of your country. And most of the country, if it happens, they will go against that. So I will not suggest that, but I think hypothetically, there are three ways a country can respond to the decision of Security Council resolution, which I explained earlier. There are three things that we could do. We do it, we ignore it, or if it's again our national interest, totally against our interest, or even threatening the existence of one country, sometimes they will go against it. I think the explanation is speak for itself, so I don't need to elaborate more because it's hypothetical. The good thing talking with the scholar is that you can say whatever you like, and it has no. That's why I dissociate myself on my professional capacity, but it is really my personal point of view. Thank you, Fatma.
Thank you, Fabrian.
Thank you, Pak Febrian, for sharing with us.
Okay, thank you. So I think that's all. Let's cover all the question that is sent directly to the speaker. But there are several questions that is directly sent to me since this participant connection is not really good. So maybe I would like to read it myself. First question is for Mr. Scott. The question is, despite the ultimate spirit of multilateralism, states' unilateralism to act in accordance to its national interest has been a challenge to multilateralism. So do you think the world or the US still need multilateralism in international relations? So that is the question for Mr. Scott. And then for the second question is for Mr. Peter Zhang. What are the challenges as the state representative to actually using international rules before the international court? And then the third question is for Pak Febrian. As for Indonesia national interest, should unilateralism be endorsed in the new international law structure? And then there's one more question for Professor Shaf Rinaldi, but the participant delivered this in Indonesia, so apologies to Mr. Scott and Mr. Peter if I may read it in. Apakah lembaga penegakan hukum dalam tataran hubungan antar negara sudah cukup? Jika tidak, apa yang perlu diperkuat? Dan jika ya, apa yang perlu dipertahankan? In English, I will translate it really. Our law enforcement agency in Indonesia at the level of interstate relation are already sufficient. If not, what needs to be strengthened? If yes, what needs to be maintained? So that's all the question that has been delivered to me directly. Maybe Mr. Scott, if you may answer the first question.
Sure. So if I understand the question, it is, is the role of multilateral institutions important when it comes to these international sanctions issues? And the answer would be yes, they are important. From the United States perspective, we work with individual countries to be able to enhance their enforcement and compliance. We work through the UN to be able to ensure that there are robust unscrews in place when there are violations of international sanctions. And we work through multilateral organizations to be able to support them. To give you a good example, you have the Asia Pacific Group, which works with countries within the region to be able to help them fulfill their financial action task force obligations, which include countering money laundering activities from certain states, as required to do so under UN Security Council resolutions. So that would be a group that we work with because it is also playing an important part of the role in being able to help enforce the unscrews however we can, bilaterally, multilaterally, and internationally. I hope that answered your question.
Okay, thank you, Mr. Scott. And then for the second question, Mr. Peter Zhang, if you may.
Yes, thank you for the question from the participant who asked it. If I understand the question correctly, it is, are there any particular challenges representing states in applying international law rules before international courts and tribunals? It's a rather broad question, but I think there's one particular way to answer, which is that at least in comparison to other types of litigation, that is cases before domestic courts or cases between two companies, representing a country in a case against another country is very particular for many reasons, but one in particular is the politics that go into it. Because you would think before an international court or tribunal, you can just make legal arguments, but the problem is that even a legal argument you put forward can also be interpreted in a political manner and can actually harm your own clients or your own country's interests. So everything that we say and do before the court has to be supervised by the country to make sure that it's consistent with their political position as well. And that can add a lot of bureaucratic hassles to the entire process.
Thank you, Mr. Peter, for the answer. So for the next question, Febrian.
Yes, thank you. The question is, should unilateralism be endorsed in international law? I think if this endorsed, I will lose my job because I'm the DG for multilateral cooperation. So I think that's quite a question which speak for itself. but what I want to say, in fact, is if we would like to judge international law, we should not judge or define by its implementability, because the implementability is always happening not only on the law, on this law, but other decision. But I think it's better for us to judge by when this commitment, this agreement are made, what is really the expectation of the people, of the parties to the agreement. If the party, the agreement, want to have it as a law, so be it. So it should not be judged by whether it can be implemented or not. But the implementation itself is the obligation of international organization to deal with this particular issue. So having said that, I think it's very important for all countries in the world try to work to make sure there's a mechanism which could help the implementation of international law. And by having that, it's not only based on the mechanism, but also the capability of the country. Like Scott said, US has helped some country to be able to upgrade their capability to implement, because sometimes it's not about the political decision or political intention that they don't want to carry out the resolution, but rather than sometimes it's their ability, their capability is not there. So their legal framework, for example, is not there. So it's really work for everybody. If you want to make the multilateralism work, if you want to make the international law work, I think it's also incumbent for us to help each other to upgrade our capability in conducting or carrying out this resolution or this so-called international decision. Thank you, Bu Fatma.
Okay, thank you, Pak Febrian, for the answer. And then lastly, Professor Syaf Rinaldi. This question sent to me in Indonesia, so I will leave it to you if you want to answer it in Indonesia or in English.
Okay. In terms of Indonesian legal enforcer agency, I think we are enough to have them, but at international level, international law enforcer agency so far is also enough, but the function of this agency, legal agency, they don't work well. Let's see, in the practice of the United Nations Security Council, the 5 members, permanent members, USA, I see that Russia, China are the opponent of the US. They are always not in line with supporting one country or the other country. Let's see if United States bring the draft of resolution to the permanent members of to the United Nations Security Council about one case, and certainly the other permanent members like China or Russia will want against this draft, they will use the veto. That means that the use of the Security Council as agency of enforcing international law are disappointed for international community because they don't carry the vision of United Nations Charter to maintain law and order, peace and security for all human beings in this earth. Thank you.
Thank you, Prof. Syaf Rinaldi, for a very wonderful answer. So, ladies and gentlemen, we finally come to the end part of this seminar. I'd like to thank so much to the speakers for the informative and interesting presentations, and to all the participants for a very engaging discussion. Hopefully, the seminar will be beneficial for everyone here and all the participants. Thank you. Wassalamualaikum warahmatullahi wabarakatuh. I will give this back to Mr. Zaki.
Okay, thank you very much. I think ISILL talk this morning is really excellent. And thank you to all speakers and moderator also, the ISILL committee. And Bapak dan Ibu, for your information, will provide e-certificates for participants who are registered in the committee database. I think that's all, and see you at the next ISILL talk.
Thank you.
Thank you. Thank you, Prof.